Mhm. Okay. All right. Good morning, everyone. I'm Dakema Welch.
I'm Judy Fairclough.
We're family law attorneys here at Orr Reno. So thank you all for coming and joining us this morning, and thanks to the Chamber for having us. We're going to have a nice and light discussion about divorce and death this morning, and how you can protect your business assets during both. So just a quick agenda. Let's see if this is going to work. Here we go. Okay. So do you want to do a brief introduction first?
Sure. We have I think the write-up was relatively broad in terms of what we were going to discuss, and we can certainly tailor it to, your needs to some extent. But we're going to be talking about prenuptial agreements and postnuptial agreements specifically we can certainly branch out into other ways to protect business interests. And definitely leave some time for specific questions because, it is, the prenup, postnup topic is probably maybe narrower than what, our audience is looking for. So we're definitely going to be available to taking questions at the end.
Do you want to give a little background
On myself?
on yourself?
Oh, you need to be very specific. Yeah. My name is Judy Fairclough. I've been practicing law since 1983, focusing on family law for pretty much the whole time. I've been at Orr Reno for about 30 years and draft a lot of prenups, a lot of postnups. And in the context of my family law practice, end up reviewing a lot of small business documentation, corporate documents that do relate to preservation or attention to valuations of small businesses in the event of divorce. And there are some ways to give yourselves as owners a little bit of protection.
Thank you. So for me, I started in law a few years ago as a paralegal up in the White Mountains. I worked for a firm that did mostly real estate transactions and trust and estate planning, largely for our small business clients because we're very tourist based up there. And then in law school, I joined Orr Reno. I did a summer associate position and internships with their family law department. I graduated last May and was sworn in last May. And so I've been here with them ever since, working with their family law department, doing mostly divorce, legal separation, and working a lot with business owners as they kind of navigate that space. All right, so to get us, we went a little too far. Let's see if I can go back. Maybe I can't go. Sorry, the mouse always lags in this room. There we go. Okay, so prenuptial and postnuptial agreements, generally speaking, they are contracts that do the same thing. The main goal is to define and allocate rights and responsibilities at a marriage termination event or death. And when we talk about a marriage termination event, what we're talking about is any sort of process that terminates a marriage. So most commonly it's divorce, but it can also mean a legal separation or an annulment. The key difference between a prenup and a postnup is when the contract is formed. So a prenup occurs before the marriage. It's typically effective upon the marriage itself, whereas a postnup occurs after the marriage. So there's a few reasons why people do postnups. Most people kind of wonder, why would I get a postnup when I just come right out of the gate with a prenup agreement? And there's quite a few reasons why. One reason is timing. So enforceability is really important when it comes to prenups. You want to make sure that there's sufficient time between negotiating, drafting, and signing that prenup and when the marriage occurs. So if people feel like they're running out of time or it's a little bit of a crunch, they might just decide to wait, hold off, get married, and get a postnup right after. And so that's a kind of probably major reason why a lot of people hold off and do the postnup. Another reason is that at the time of the marriage, there just weren't any assets to protect. Maybe someone received a large inheritance they weren't expecting to receive after the marriage, or decided to open up their business after the marriage. And so a postnup is great for that because then you can protect those assets. Another reason is there's a change in the relationship. Sometimes, and most of the times when postnups occur, it's because there's been some sort of breakdown in the marriage, whether it be an affair or something else. Maybe the parties decide, let's give it a shot, let's stay together, see if we can work through it. But the business owner or someone else who has, an asset they're looking to protect wants to make sure that they can do that in the event that they aren't able to resolve any marital issues. Any other thoughts from help?
I've been doing a lot more post-nups. I've been doing them for a long time, even though they weren't specifically authorized by statute or case law, and now they are. We don't have the specific guidance that we have with prenups because the law hasn't developed as much, but another one thing that I've seen are individuals who want to align their prior prenup with, as Dakema said, the change in assets, but also sometimes to align it with their estate plan. And some folks didn't have a prenup to begin with and realized for various reasons, such as Dakema mentioned, that it would be a good idea to have one. But I am seeing a lot more postnups primarily to align their current situation with the development of acquisition of assets.
So another important thing to note about prenups and postnups is they're treated with a little bit more heightened scrutiny in comparison to other contracts, and that's largely due to the nature of the agreement and the relationship between the parties. And when we're looking at what's involved in a prenup and a postnup, in kind of the most basic sense, if we were to boil it really down, it's about defining and allocating marital property. So we're defining what assets belong to each party and what assets belong to the marriage. So really simply, what's mine, what's yours, and what's ours. And then we're taking it a step further and saying, in an event of a marriage termination event or death, like who gets what and where do we go from here? And the definitions and terms that are in a prenup or postnup are and can be tailored to fit each couple. So as Judy just mentioned, maybe there's a change in financial circumstance or something else. It's not a one size fits all situation. So these terms and definitions can be negotiated and swapped out and things like that to reflect what the parties need and what their goals are.
I see a lot of individuals who, a lot of second marriages and individuals who want to protect assets, including business assets for their family. And then there seem to be a lot of situations where a business owner has a child who's getting married and they want to protect the business and or the inheritance. So the couple may not have much at all in terms of assets, but when we look, down the road, they stand to inherit quite a bit. And that's where we get into, the business formation of the parents. And I did have one situation where the spouse to be, the fiance, didn't even know the extent of his future wife's inheritance. So that was kind of interesting, had never really come up. So I think he was probably happy. But we see them in a variety of situations. It's not just the very wealthy, and it's not just, I call it the gray marriages.
Okay, so when we're talking about the structure of prenups, kind of the most common structure, and again, if we're talking in very basic terms, is that whatever assets or debts that a party brings into a marriage, inherits, acquires, maintains, and keeps in their own name is theirs. It's their separate property. So what that means is that at the time of divorce or legal separation, that asset is off the table. It's not included in the marital estate. It goes with that person. It also means that it's up to that person how they account for it and manage it in their estate planning. Whereas any assets or debts that the parties acquired jointly or titled jointly in their names would be considered marital property and subject to division at divorce or legal separation. And ideally, the parties would be deciding together how that asset's managed through estate planning. And some of you have probably already connected the dots here a little bit, but when we're talking about prenups and postnups and why they're helpful for business owners, we can define business itself, the assets, and even its profits as separate property, which is a really great way to protect those assets at the outset. Anything else before we? Cool. Okay, so now we can move in and hopefully, perfect. So when we talk about benefits, there's quite a few, but we've kind of boiled it down to three main ones. So the first one is minimizing statutory consequences. And what does that mean? So essentially what we're looking to do is avoid certain statutory obligations that exist for spouses at the time of death or divorce because they are spouses. So in divorce or legal separation, we're talking about property division and alimony. There are statutes that guide how spouses should be dividing their property, their assets, their debts, and there's also statutory guidelines about alimony, which I think probably most people are familiar with or aware of, but essentially that's when one party has a need, the other party has an ability to pay, and so they're providing some financial support so they can meet their needs for some defined period of time. And there's a lot of statutory guidelines on how that's calculated, if and when it's appropriate, duration, all of those things. And then when we're looking at death, the biggest statutory consequence that people tend to want to avoid is what's called an elective share. An elective share, it's a little bit complicated, but to kind of put it a little bit simply, it's a mechanism where a spouse can forego the gift that their deceased spouse left for them in their estate planning for presumably a larger share that's defined in a state statute. It's impacted by a lot of things, but mostly it's impacted by what other living relatives have also, outlived the decedent. And so that's probably, I think, in death, the biggest statutory consequence that folks are looking to avoid when we're talking about protecting business assets or prenups and postnups. And so to fully appreciate how prenups and postnups work to avoid statutory schemes, the biggest and probably most clear way to see that is when we talk about what happens to a business at divorce. And so if a party owns a business and they wish to use a prenup or a postnup to safeguard it, what they would do is define the business as their separate property. And again, that just means that it's off the table at divorce. So it's not a part of the marital estate, it's theirs. It's not even factored in. And of course, you want to make sure that you're using really well drafted and clear language to make sure that happens. But assuming you do so, that's yours, it's not factored in. The business owner can also include what's called an alimony waiver to help protect business income. And they can also define business profits as separate property, which is another way to protect business funds that might come in pre and post divorce. And what's really important when we're talking about protecting these assets and keeping them separate property is that parties do not commingle assets after the prenup or postnup has been drafted. If you want it to be separate property, you really have to keep it separate property, right? So if you add your spouse to titles for your business, if you start putting business income into joint accounts, then depending on how you've defined separate property in your prenup and postnup, it may no longer be protected. It may now be marital property. So you really want to make sure if the goal is to keep the business, its income, its assets separate, that you're not adding your spouse to title and you're not, commingling assets in any way.
One thing that Dakema touched on is in terms of defining income. Income is a key component of alimony. So to the extent there is either inheritance income or business income, dividends, how are you defining profits? The more detail, the better, but there you can certainly shield certain business income from being included as income in the alimony calculation. I will say that the alimony piece is probably oftentimes it's the weakest link of a prenup. Folks who want to waive alimony, I think, risk having that part of the agreement set aside. So in addressing alimony and in addressing what constitutes income, it's oftentimes better to have some provision or a very, very clear definition that's agreed upon so that the alimony waiver or the alimony provision will be enforced. It's also important not to consider a prenup as a substitute for an estate plan. Death is a marriage termination event, but they really are two different documents and they should, dovetail and be consistent with one another. But you can see from what Dakema is saying that it is a very important element in terms of succession planning for small businesses, particularly if you have, one spouse who's very involved in a family or a small business and the other spouse who's not.
Right. And we see that especially in folks who don't have any sort of prenup or postnup or succession planning, whether it be estate planning or corporate documents. So if you're a business owner and you don't have a prenup or a postnup and you are getting divorced or becoming legally separated, the process becomes much different and much more complicated. So when it comes to property division, our statute requires that all property that belongs to each individual spouse and jointly is kind of dumped all into one big pot, and it's all considered marital property. It doesn't matter who holds title to it. It doesn't matter how they acquired it, whether they inherited it or invested and worked really hard to, maintain it and grow it. None of those things really matter when it comes to its determining marital property. So it's all in the pot. It's all up for grabs. Those things do come into play when we talk about who gets what in the marital estate. So ideally, and hopefully we tend to push our clients to mediate and settle and we reach agreements together. But if we end up not being able to do that when we're before a judge, it's up to the judge to kind of determine who gets what and how we're dividing things. And so what does that look like? Our court, like I said, in our state tends to lean towards equitable distribution unless for some reason there's been some sort of fault or something that might sway in favor of one party over another. But generally speaking, we're looking at an equitable division. And so that doesn't mean the court's going to come right down the middle and split every single asset 50-50. You're not going to be forced to carry on a business with your ex-spouse in perpetuity, right? I guess they could order that, but I think most judges and most courts like to unwind the parties. So what's likely to happen is that the business would have to be appraised, would have to assign some sort of value to the business. Likely, I would say more often than not, very likely, the business would be awarded to the business owner and that value would be assigned to them. So what that means when we're talking about equitable distribution is that the other spouse now needs to have some sort of balance, right? We need to move something into their column to offset the value of the business going to the business owner. Usually that's by, giving them some other sort of high value asset. But if there's not sufficient assets, then maybe that means the business owner needs to pay out their spouse in order to maintain and keep their business. And then when it comes to alimony, presuming the non-owner has a need for alimony and the owner has an ability to pay, we get into a lot of different nuances about what income is the business owner really receiving. Is it just their draw that they take every week? Are they a W-2? Do they get regular pay? Is there other income in the business that they're not taking but should be? Alimony becomes a little bit more complicated. Okay, so it's kind of a really long way of explaining that defining businesses, their assets and their profits as separate property in prenups and postnups, doing so really effectively can make a really big difference in the divorce process or legal separation process. And that also relates to limiting risks. So if a prenup or postnup is well drafted and enforceable, the settlement of property division and alimony in the event of a marriage termination event is already determined, right? The parties have planned in advance. If we are to divorce or separate, where do we go from here? They have a map. And so realistically, most parties tend to settle when they have a prenup or a postnup relatively quickly. And that saves parties quite a bit of time. It saves significant expense when it comes to attorney's fees, but it also saves the emotional toll of going through a divorce process. And it also allows parties to limit the involvement of a judge, which is really important too. But if we're absent of any sort of prenup, postnup, or an agreement, like I said before, we're going to a trial, a final hearing, and a judge is making decisions on how we define our property, including our business. And so it's a lot of time. It's very costly. You could be looking at 5 to 6 figures of attorney's fees. And then you also have that, stress and that emotional toll of what's going to happen to my business? How is this going to shake out for me? So most business owners tend to want to complete the process efficiently, effectively, and they also want to make sure that they can maintain control and ownership of their business. A well-drafted prenup or postnup is a great tool to reach that goal, and it also takes the fate of your business out of the hands of a third party like a judge, right? They have statutes, they have case law that they're supposed to follow, but at the end of the day, judges are people too. People are really unpredictable, and you can't determine what a judge may or may not do. It's going to vary between court. It's going to vary, sometimes judges, it's day to day. So if you can take that risk out and, put it into a prenup and a postnup and ensure that you know what's going to happen, especially as to your business, that can be a big peace of mind to a lot of business owners.
Yeah, it's a lot of managing expectations as well, and it's a subject that particularly young couples have a hard time talking about money, finances, what do you have? What is this business all about? And that actually is a really important step, I think, for people about to be married. And when you think about it, Dakeema's talking about the statutory consequences of not having a prenup. Everyone really has one. It's just they don't get to write it. The judge gets to write it. So, and the statutes, can be very impactful, and to many can seem like they would result in an unfair ruling. So managing expectations and limiting risk is huge, really, when it comes down to it, particularly if you're talking about a business.
Yeah. And Judy already touched on the managing wealth piece a little bit, but prenups and postnups are a useful tool to manage and protect family wealth. So if someone has a multi-generational or closely held family business, or if they're looking to provide for children from prior relationships, prenups and postnups can help achieve those goals as well. Okay, so we just spent a lot of time talking about prenups and postnups, but there are some other ways to protect business assets if you're not interested in a prenup or postnup. So the first one is probably, we're back. So the first one is nothing, probably not the most advisable, but some people do choose to do nothing, right? Talking about getting a prenup or a postnup can be really, really uncomfortable. Some people can worry that it will cause a rift in their relationship with their future or current spouse. And this is true of, families, parents, business partners, if they want to encourage their child, their sibling, their, business partner to get a prenup. It can be a really tricky conversation. Some people, kind of weigh the risk against emotional comfort and decide, I don't want to do anything. I'm comfortable proceeding without one. And so that is an option. The next is irrevocable trust. So generally speaking, the way an irrevocable trust works is that once it's created, generally it can't be changed or terminated, and any asset that's placed in it can't be taken out of it, right? So if you put your business in an irrevocable trust, generally speaking, that's where it exists, that's where it is. And so it's an estate planning tool that a lot of people use to hold assets, shield them from creditors, as presuming that there's specific provisions that are in the trust instrument. Sometimes the business owner is actually a parent, as Judy highlighted before. Their child's getting married and they know that they want to pass their business on to their child at some point. And so an irrevocable trust is a good way to protect that. It allows them to pass their business on or business assets profits down without having to worry about, their soon-to-be in-law or current in-law having any sort of interest in it if that's what they're concerned about. Especially if they include what's called a spendthrift provision that complies with our statute. That will also help exclude the business from the marital estate should there be a divorce or legal separation. With irrevocable trust, it is important to remember, though, that any sort of asset or income that the child receives outright wouldn't be protected. That wouldn't be separate from marital property. Sometimes, depending on the business owner and what their goal is, that's sufficient and that's fine. It's really up to them to weigh, what they need and what their goals are. Another mechanism is your corporate documents. So these are the documents that are drafted to create and manage your business. It's typically an operating agreement or articles of incorporation, something similar. These are the documents that provide guidance and rules and regulations on how the business is formed, how it runs. Oftentimes they talk about ownership, management, profit, loss, distributions, what happens if the business were to, dissolve, things like that. So if there is no irrevocable trust and maybe you're concerned, maybe you're a business partner whose partner is getting married soon and you want to make sure that you are protecting your end of the business, looking at your corporate documents is a really good place to start. Oftentimes death is accounted for, but divorce and legal separation not as common. Sometimes there's a right of first refusal, which can help with valuing or talking about how we transfer the business assets on. But again, if you have an irrevocable trust or any sort of corporate document, what you're going to want to do is go back to the attorney that drafted it, your estate planning attorney, your business attorney, tell them what your concerns are, what your goals are, and review it with them. And maybe you're drafting amendments and having those implemented, or maybe you're talking about drafting a new document, updates, whatever. But it's best to go back to them, go back to the drawing table. Maybe your needs are met, or maybe they can be tweaked without having to do a prenup or a postnup.
So in terms of the corporate documents, what I've seen is a lot of times in medical practices for some reason, but not only defining in either a shareholders agreement or a member agreement, how the interest would be allocated in the event of divorce, but actually considering a valuation formula. We see them a lot in member agreements and shareholder agreements. If a partner is going to leave or a member is going to leave, and there's usually a formula for that. So we've seen the family courts actually look to that for guidance, even though it's not binding, and it may not be at all what a divorcing spouse would want the valuation to be. Sometimes you'll have a spouse or a member go through a divorce. The other members see what occurred. They don't want to be in that situation, and you're really involving your partners in these decisions. So that's oops, we should have done that before. So oftentimes we see changes to the corporate documents in those situations. But there is a fair amount that you can do outside of the prenup or outside of an irrevocable trust if you have buy-in from all of your members or shareholders.
So moving into some key takeaways. We just dumped a ton of information on you. So just kind of like a quick, easy process for yourself, or if you're working with clients. The first step that a client or business owner should take if they're concerned about protecting their business assets is to assess the need for a prenup or a postnup agreement. The next thing that they should do, if they have current instruments, whether it's estate planning or corporate documents, as we kind of touched on before, meet with their attorney that drafted it and see if their needs are already met. If not, if they don't have those documents or if their needs aren't met, they can evaluate what other alternatives might be appropriate. Maybe it's an amendment, maybe it's drafting a new document, or maybe it is a prenup or postnup. The next thing that they should do is involve professionals as needed. Businesses are complex. There's a lot of moving pieces. We work hand in hand oftentimes when we're doing divorce settlements or drafting prenups and postnups with CPAs, financial advisors, your estate planning attorney, your business attorney. So don't be hesitant in any way to loop in your team, your network, and connect people so that we can have conversations and make sure that we're addressing any sort of concern or vulnerabilities that might exist. And then lastly, what you want to do is make sure all of your agreements work in concert with another. You don't want your prenup or postnup to conflict with estate planning or vice versa. When that happens, we end up walking into a bit of an enforceability nightmare, right? Which document controls, which terms are we following, which ones are we not following? So if you're drafting new documents, you want to make sure, again, looping in your team of professionals, making sure that all of your documents work together and there's no conflicts.
Well said. On the involving professionals piece, I can't tell you how many potential clients have called and said, well, it's really a form, right? Can I do this online? I wouldn't. There is certainly a fair amount of, I suppose you might say kind of boilerplate language, but it's really the guts of the agreement where you want to make sure that you've got a professional helping you, not only to make sure it's drafted in such a way as to avoid legal challenge, but also to have a set of eyes looking at tax issues. How does this impact your business? So it is really important to make sure you have an attorney do it. And under New Hampshire law, it's better if both individuals have an attorney. It is not required that both have an attorney. Both need to have what the cases say, an opportunity to consult with legal counsel. But when I'm meeting with someone about a prenup or a postnup, I want to make sure the other person has counsel.
Great. That's it for us on our end. Does anyone have any questions or anything they want us to discuss, maybe a little bit more in depth?
Is there anything that cannot be included in a prenup or postnup?
The big no-no is anything that has to do with children. Child support, parenting arrangements, you know, what we used to call custody. The court is, and when someone says, I want this to be ironclad, bulletproof, well, there isn't really bulletproof prenup. We do the best we can. We create very strong documents, but the court is going to look to see if it is so one-sided as to be fundamentally unfair. So you do have to be careful with that. The days of you get what you brought in, I get what I brought in. We really need to tweak that because we want to make sure that we don't have one spouse getting $100,000 and the other spouse getting 20 million. So it's oftentimes better to have some provision for the lower property spouse. It's harder to attack something than it is to attack, you know, well, I didn't get anything. So you do need to bear in mind that the court takes a second look. They look at the time of drafting and also the time of enforcement. So it's kind of an offshoot of your question. You do need to make sure that there's an element of fundamental fairness. It's not going to be what the statute says, otherwise wouldn't need it. And it's in fact to avoid the presumption in a longer term marriage of a 50-50 division of property. But you can, otherwise you really, the sky's the limit. You can, I caution my clients from being too detailed, like, well, I want to make sure that he pays, you know, half the utilities and, you know, you want to make sure it's a workable agreement. But you can, you know, come to the table with as many ideas as you want. Because they're, other than the child issue, you really can use it to address whatever you want. And some prenups only address the business assets and leave the rest to the statute or the judge or fate, kind of all the same thing. So it can be as specific or as all encompassing as meets your needs.
And the courts are also gonna look at any sort of substantial change in circumstance too. One that kind of recently came up, I think a couple summers ago, was at the time the parties were married and had their prenup, they were both, you know, working pretty similar jobs, earning pretty similarly. They were married for, I think, 15 or so years. And what ended up happening was one party decided to go back to school, become a medical doctor, become a surgeon, and was then earning, you know, way more than the parties had ever dreamed of earning at the time that they were married and at the time of the prenup. And so the prenup didn't really fit anymore, even though they had it, because their circumstances had changed so significantly. So that's another piece that parties are going to want to look at too. And I think Judy hinted at this a bit too, is if there is a big change either in your business and its performance or your income or any sort of finances, you're going to want to make sure you're going back and looking at the prenup and seeing if it still applies, if it still fits, and if not, what should we do to cover our bases.
Each party would need to be represented by a separate counsel, right? They can't be both under you.
Preferably, each party would have an attorney and they need separate representation. I have started doing what I'd call a mediated prenuptial agreement, where I would meet with both parties, put something together that really meets their needs because we're sitting together and going through it. And then they each have to take it to separate counsel. And as I send them off, I just hope that that they're going to lawyers who are going to respect, you know, what the parties have decided they want to do. But the one lawyer cannot draft the prenup for both as, you know, joint counsel.
All right, well, if there's not any other questions.
Do you guys do ILITs, like irrevocable life insurance trusts?
We deal with them. I don't know that our estate planning department drafts them, but we have a pretty sophisticated group of estate planners that I like to have one of our estate planners look through my prenups before I send them out, particularly if they're, you know, complicated, just to make sure that what we're proposing is something that can actually be accomplished. So we do oftentimes see the irrevocable life insurance trusts. We don't draft them, but that may be something that our office does.
Any other questions? All right, well, we can probably break then. I think we have some time left over, so enjoy some breakfast treats, networking.
Are there
Um,
questions from the audience?
Nothing online. We're good.
Okay.
All right, well, thank you guys again for coming and joining us this morning.
Thank you so much.
And coffee. Questions yet?